The politics of France take place with the framework of a semi-presidential system determined by the French Constitution of the Fifth Republic. The nation declares itself to be an indivisible, secular, democratic, and social republic. The Constitution provides for a separation of powers and proclaims France's attachment to the rights of man and the principles of national sovereignty as defined by the Declaration of 1789. The political system of France consists of an executive branch, a legislative branch and a judicial branch. Executive power is exercised by the President of the Republic and the government. The government consists of the Prime Minister and ministers. The Prime Minister is appointed by the President, and is responsible to Parliament. The government, including the Prime Minister, can be revoked by the National Assembly, the lower house of Parliament, through a censure motion. This ensures that the Prime Minister is always supported by a majority of the lower house. Parliament comprises the National Assembly and the Senate. It passes statutes and votes on the budget. It controls the action of the executive through formal questioning on the floor of the Houses of Parliament and by establishing commissions of inquiry. The constitutionality of the statutes is checked by the Constitutional Council, members of which are appointed by the President of the Republic, the President of the National Assembly, and the President of the Senate. Former presidents of the Republic also are members of the Council. The Independent Judiciary is based upon civil law system which evolved from the Napoleonic codes. It is divided into the judicial branch and the administrative branch, each with their own independent Supreme Court of Appeal, the Court of Cassation for the judicial courts and the Conseil d'État for the administrative courts. The French government includes various bodies that check abuses of power and independent agencies. France is a unitary state. However, its administrative subdivisions, regions, departments and communes have various legal functions, and the national government is prohibited from intruding into their normal operations. France was a founding member of the European Coal and Steel Community, later the European Union. As such, France has transferred part of its sovereignty to European institutions, as provided by its constitution. The French government therefore has to abide by European treaties, directives and regulations. Constitution. A popular referendum approved the Constitution of the French Fifth Republic in 1958. Greatly strengthening the authority of the presidency and the executive with respect to Parliament. The Constitution does not contain a Bill of Rights in itself, but its preamble mentions that France should follow the principles of the Declaration of the Rights of Man of the Citizen, as well as those of the preamble to the Constitution of the Fourth Republic. This has been judged to imply that the principles laid forth in those texts have constitutional value, and that legislation infringing on those principles should be found unconstitutional if a recourse is filed before the Constitutional Council. Also, recent modifications of the Constitution have added a reference in the preamble to an environment charter that has full constitutional value, and a right for citizens to contest the constitutionality of a statute before the Constitutional Council. The foundational principles of the Constitution include the equality of all citizens before law, and the rejection of special class privileges such as those that existed prior to the French Revolution, presumption of innocence, freedom of speech, freedom of opinion including freedom of religion, the guarantee of property against arbitrary seizure, the accountability of government agents to the citizenry,